Assalamualaikum to our lecturer, Professor Madya Dr. Muhammad Shahnawi, Muhammad Firuz, and to all who watch this video. Like to introduce myself, I'm Norbasrah Ali, ID number 2023217516 from Interpersonal Communication Studies in Faculty Bachelor of Communication and Media Studies MC247. So for this individual assignment for INC500 Industrial Regulation and Cybersecurity. Today, for cases of law and industrial relation, I choose case about appellant Suraj Ramasamy with plaintiff Hong Leong Bank Berhad. So we go through to the facts of the case, which is the appellant Suraj Ramasamy was employed as the head of Group Information Technology Security at Hong Leong Bank beginning 19 September 2016. On 28 July 2020, he was suspended pending investigation after presenting manipulated survey data to the Board of Information and Technology Committee. The third facts of the case, on 1 September 2020, he was dismissed on grounds of serious misconduct, notably misrepresentation regarding a cybersecurity awareness survey. He claimed unfair dismissal under Section 20 of the Industrial Relations Act 1967. The fifth of the facts of the case, the Industrial Court found the dismissal was with just cause and excuse. The last one, the appellants then appealed to the High Court. So we go to the issue of the case. The case one, whether the dismissal of the appellants by the bank was with just cause or excuse. The second case, whether the appellant's misrepresentation and misconduct by the appellant warranted termination, and the third case, whether there were ulterior motive, procedural impropriety, or disproportionate punishment in the dismissal. So the judgment of the case, the High Court dismissed the appeal and affirmed the Industrial Court's decision. There was find a key of the judgment. Is it misrepresentation to the PITC was proven? The second one, the misconduct was prejudicial to the bank. There was no evidence of malaise or ulterior motive in the dismissal. The dismissal was proportionate to the misconduct. The five keys finding: procedural lapse, example no show cause letter, were cured by the Industrial Court proceeding. So we go to the analysis and critique. The first analysis of the misrepresentation, the High Court accept that the appellants deliberately doctored survey result claiming 290 response were only 59 were recorded. He also edited screenshot and presented them without disclosure. The High Court emphasized trust and integrity in the banking industry, representing Blanco Oil Mill versus Oil Ching Land and Harian to Effendi Zakaria versus Mahkamah Perusahaan Malaysia to highlight the importance of data integrity. The second analysis, procedural fairness. The appellants argued he was not issued to show cause letter and had no opportunity to appeal. However, the court seat Wong Yuan Hock versus Syarikat Hong Leong Insurance Sdn Bhd to show that procedural defects can be cured by fair industrial court hearing. The third analysis, like ulterior motive, which is the appellant's claim that his superior had pure intention to dismiss him. The court found this argument speculative as no causal nexus was proven between past conservations and the eventual dismissal. Next analysis, weight of evidence. The court notes that while the industrial courts erred in relying on an untested statement by Ms. Gayatri, is it an out-of-court statement, there was ample other evidence to support the dismissal. The last one of analysis, proportionality of dismissal, which is the appellant's claim the penalty was excessive, and the court citing Haryanto Effendi emphasized that even lesser misconduct can justify dismissal in high trust industries like banking. So, the critique of this case, the court reasoning is legally sound and consistent with established industrial jurisprudence. The second one, the reliance on precedents affirming strict standard for trust and honestly in financial inappropriate. The third one, however, the error of relying on untested hearsay evidence, Ms. Gayatri's declaration is notably, while the High Court ultimately discounted it. The industrial court's reliance on it show a potential procedural lapse. And the last of the critique, they failed to issue the formal show cause letter could have been more deeply scrutinized for fairness. Truth, the court justified it adequately through case law. So, thank you for watching. This is my reference for this case. Thank you.